Hello, everybody. We're just getting everyone in here. I'm going to start sharing my screen in just a second. This is the March 22nd Homeline webinar series installment. Today we'll be covering leases, lease basics. So we'll sit tight here for just a little bit because I know we had quite a large number of people register. So we will just give it a couple extra minutes for people to actually come in and before we get started. All right, so folks, you should be able to see a nice blue slide that says Land of 10,000 Leases, Understanding Leases in Minnesota on your screens. Amar, Mike, can you confirm that for me?
Yes.
Perfect, thank you very much.
Go for Mike.
Perfect, thank you. All right. Again, we're still getting some folks in, so I wanted to give a couple extra minutes since we did have quite a few registrants. I'm not sure how to pronounce the A in that word. But we'll get started here in just a minute. And for those of you who are just showing up, we welcome to our webinar. That's the word. You would think that over the last 2 years I would have pronounced it and said that word sufficient times that it's just embedded in my brain. But this is Homeline's webinar series. Today we'll be covering leases, understanding basic leases in Minnesota. We have a lot to get through today, so I think at this point it looks like we're slowing down on people joining us. So I'm going to go ahead and get us started. My name is Rachel Sterling. I'm a housing attorney here with Homeline. We are joined today by Amma Carrion, who is going to be giving us a presentation on lease basics here in Minnesota, because they can get confusing, to say the least. And we'll also be joined by our managing attorney, Mike Vara, at the end to answer some of the questions, just so that and I can breathe air and drink water on occasion. So what is Homeline, in case this is your first time around? We've been doing these presentations for almost 3 years now. And so Homeline itself, though, is a statewide nonprofit organization that provides legal, educational, and advocacy services and advice to renters across the state of Minnesota. We've advised I think it's over 300,000 renters now, or we're very close to that number.
Closing in, not there yet.
Okay, so we're very close to that since 1992, so 31 so odd years ago. We offer our services in 4 languages, English, Somali, Hmong, and Spanish, as well as an email and attorney option. If you prefer that sort of communication, those numbers are up on the screen, and we'll also have them again at the end of the presentation. And so just a couple of housekeeping things. We will be applying for 1.5 standard CLE credits at the end of this. That is probably going to take a couple of weeks for us to then email y'all who want CLE credits with that code. So please be patient while that is being dealt with. We will apply for them today or tomorrow, but it's been taking some time for that to get processed. The session is being recorded and will be available on our website in a few days. We'll also have a link to a PDF version of these slides as well for your reference. And We do encourage questions. It's one of the things that I think is a strength of these webinars over the last 3 years is that we encourage and go through a lot of questions. So if you have questions, please ask them. But please use that Q&A function that you can see at the bottom of your screen. That is going to be the best place for them. It is, if you put it in the chat, I will miss it. And I feel badly then when I go through the chat later on and see that you had a question that I missed completely. So please use the Q&A function to ask your questions. And so without further ado, that's my housekeeping. I am going to turn it over to our supervising attorney, Ama. Thank you so much.
Hi.
Hey.
So let's get this started. We are on Minnesota, the land of 1,000 leases, or 10,000 leases, I'm sorry. Next slide, please. So the first thing we need to look at are what are the elements of a contract? And next slide. So there's three things that we look at when there's a contract. The first one is the offer. The party says that they're going to do or not do something in the future. Then there's consideration. The value of that doing or not doing something comes with a cost. And then the acceptance. The person who wants the something or the not something done says that they accept this offer. Now, this acceptance is unambiguous. No one has a single doubt that this was an agreement. And it can be through words, it can be in writing, or it's just a performance when someone does the something in exchange for money or services or whatever it is that has been agreed upon. Next slide, please. So then what is a lease? And a lease is a contract. Next slide. It transfers the use of property or occupancy of a land or a space or a structure in exchange for money, labor, or a combination of both. In Minnesota, this is a temporary use of a property, and it means that once parties enter into this agreement, it is a binding rental contract. That's what is a lease in Minnesota. You basically say, I have this land or this structure, and I'm offering it to you for a certain amount of money, or for you to do maintenance in the structure or repair it. Whatever it is the consideration. Once there's an agreement, then you have a binding rental contract. Next slide. So what are the types of leases here in Minnesota? Next slide, please. They're verbal or written. In general, there's no requirement that a contract be in writing. In Minnesota, landlords and tenants can reach an agreement either way, and that establishes a landlord-tenant relationship. However, let's see how entering into this agreement looks like now. What's the next slide? Entering into the agreement and putting it in writing gives additional clarity to what the expectations are for both parties that are entering into it, the landlord and the tenant. However, in Minnesota, rental agreements already contain all the elements required for a contract. So the essential elements are already fixed, and then any other terms that the landlord and the tenant agree to can be whatever they want them to be. And those are usually the ones that people put in writing. Next slide, please. So we created a little video of the top 5 terms to look for in a lease. Go ahead, Rachel.
I want to, oh no. What happened here? Oh, I thought I was being very clever. The last time we tried to do a video on one of these, it didn't work out well. So I thought I would be clever and put it on our page, and that hasn't worked. So let me do something really quick, and then we will come back to that. Okay.
Try it from the slide. Maybe it's working.
I mean, maybe. No. Let me do something really quick. I apologize, everybody, for the delay here. It's a really great video, so I do want you all to see it. Amma did a really good job of getting it put together here, so I want to acknowledge that. All right.
Yeah, we need to make sure that my moment as a TikToker, or my version of a TikToker, lives in infamy.
Well, I mean, how else are we going to know that you got where you got your start?
Oh, that's true.
Okay, here we go. Can you hear it?
It's too low.
Yeah, we can't hear this, Rachel.
All right. Well,
Okay.
that is as good as I was going to be able to get it. Well, it's going to be posted along with the video and recording of all of this. So, if you
There's the
wouldn't mind,
video.
yes, the video exists and will be available and playable to all of you after this is done. Thank you for that. All right. So we will go back to our slideshow.
Regularly scheduled programming.
Yes. And so if you could go over
Yeah,
what
I'll
you
go over what
had.
the lease, what the video had. So basically, the top 5 list, number 5, is to include all mandatory provisions and disclosures as required by law. Number 4. Hold on. Number 4 was to make sure that all fees, I believe it was all fees, are listed. Number 3, Rachel, do you remember them all?
Yes, I believe it was. So it was parking fees, early termination fees, pet fees, and most importantly, not notice disclosures. That was in number 4. Yeah, parking, pet.
Basically, it's all fees.
Yeah, all fees.
If you're going to come up with a fee, it better be on the lease. Yeah. You need to make sure that you include in the terms any notice requirements that you're going to require from the tenant, which also applies to the landlord. You need to include who is going to be on the lease. What are the names of the parties? The address of the property. And you need to include what you're going to charge in rent. So those are, it's a little listicle that we came up with. The video is going to be more clear because obviously right now we're doing it off the top of our heads.
And I will put it in the chat as well here quick so folks can see it. But
all right.
If you want to continue on, it will also be very clearly in that video.
Next slide. So before you sign on the dotted line, I hope you like my John and Jane Doe signature. Let's go to the next slide. The tenant should see the unit that they are renting. Sometimes landlords will have sort of sample units, and that's fine to look at those. But before you sign on the dotted line as a tenant, you should go see the unit that you're planning on renting. This is because you want to make sure that you're getting what you are being offered and that you like the unit itself. You like the light, you like the location in the property. You like how close it is to emergency exits or the floor that it's on. Also, you want to verify that the utilities are working. So check the water pressure, turn on the light switches, check the elevator. Check if the appliances are operational. Make sure that the refrigerator is working, that the stove turns on, if there are air conditioners, that they turn on. If the washer and dryer is working. Those are things that you should always check before you move in, and most definitely before you sign on the dotted line. For single metered buildings, landlords really should provide a total utility cost for the building on the most recent calendar year. We get calls, especially now with the increase in utilities, where people get sticker shock. So this is just a good way to avert any confrontations based on that. Next slide, please. Any tenants should ask for any deficiencies to be corrected if any are present. So if you notice that the dishwasher wasn't working or the air conditioner wasn't working, there's some peeling paint, all those things, like the carpet doesn't look clean, you should ask before you sign the dotted line that those deficiencies be corrected. The landlord doesn't necessarily have to agree to do them immediately, but then that gives you as a tenant, if you're the tenant, sort of an opportunity to decide if that's a place where you want to rent. And as a landlord, also gives you an opportunity to correct anything that might be not in working order or not looking great. And then tenants should always check if a unit is licensed in those cities where licensing is required. Remember, landlords, if you don't have a license in a city that requires a licensing of a property, you can't accept or keep rent until you're in compliance. I think there were some slides. I want to say they're in the chat. Hold on a second. So someone is asking about fees. I'm going to address fees later. So if you can post a question in the Q&A, we'll go over that.
Yeah, the chat is, we're going to lose track of the questions there.
Yeah.
So, but I did post the top 5 things to include in a lease.
So there's a question, a specific question about someone in an emergency shelter program. Could you please have that tenant contact us at our hotline? That's a very specific question and we'll be able to answer it, but we do need to speak to the tenant directly. All right, next question, please. Slide. So the rule against perpetuities, and Rachel, I'm doing this one for you. Next slide. It's a non-vested property interest is invalid unless when the interest is created, it is created to vest or terminate no later than 21 years after the death of an individual when alive, or the interest vests or terminates within 90 years after its creation. Next slide. Yeah, I don't know what that means either. What it matters is how it applies to leases. And the question is, can a lease really last indefinitely? And the answer is no. Any lease that you enter into that has a limited duration, so a term lease, or a lease that you enter with an indefinite term, a month-to-month lease, really has to be renewed. So month-to-month leases conclude after the minimum term, that will be a month usually, and it is renewed because neither party has given notice to end that term lease. If you're in a term lease and a 1-year lease, 6-month lease, the lease ends when the lease says it ends. However, people need to pay attention to notice requirements because you do need to give notice of whether you're renewing your lease or not. In month-to-month leases, the common notice period is 30 days. For term leases, the most common one is 60 days. It doesn't mean that's written in stone. It could be 90 days. It could be 30 days for either one. And there is a restriction, statutory restriction on automatic renewal of leases. It's statute 504B period 145. Landlords definitely review it if you have automatic renewal of lease clauses in your leases. And tenants, you should always review that statute because you want to make sure that the landlord is following through with it if you have an automatic renewal clause on your lease. So, Emily, you should definitely put the questions in the Q&A because I will miss them. The question is 30 days plus 1 for lease termination of month to month. It's 30 days. And it has to be in writing. The statute that you would want to look at is 504B, period 135. Unless you were on a term lease that ended and then it had a clause that said that it would turn into a month-to-month lease, and then you're basically continuing with the lease, the notice requirements of the original lease. So what are the common lease questions that we get at Homeline? Next slide, please. Can a landlord charge me for repairs? That's a no. The landlord has the responsibility to conduct maintenance. It's codified in statute 504B, period 161. However, a landlord can charge a tenant for any damage that they have caused that it's due to the tenant's willful, malicious, or irresponsible conduct. So let's say you were in the tub and it flooded the bathroom because you forgot to turn off the water and flooded the apartment. That would be a repair that you as a tenant would be responsible for. But say, for example, there's an electrical fire. That's not your responsibility as a tenant to fix because you didn't cause the fire due to your willful, malicious, or irresponsible conduct unless you were, I don't know, sticking screws or whatever into the outlet. Next slide, please. How long does the landlord have to make repairs? Generally speaking, the landlord has 14 days to do non-emergency repairs, but any emergency matters need to be addressed within 24 hours. Now, does the landlord have a right to enter the unit without 24-hour notice? In Minnesota, the standard is really reasonable notice. So that can be more or it can be less than 24 hours. However, if your lease says that the landlord is giving you 24 hours notice, that is part of the agreement you've entered with the landlord, and 24-hour notice needs to be given. If a landlord or their agent, so maintenance people, enters your unit without notice, they really need to leave a note detailing why they entered the unit, when, and what it is that they repaired or touched. This is very common when people have submitted repair requests. It's usually happens within that 14-day window. The landlord will not, or the maintenance people will knock on the door. And if you're not there, they'll enter because they have a repair request. And you need to look for that piece of paper that says when they came in, what they fixed, or what they saw. Next slide, please. Who is responsible for snow removal and yard work? We get this question a lot. And the answer is the landlord. Regardless of what the lease says, maintenance is the providence of the landlord. And with snow removal and yard work, it's very typical in leases for houses. This is where we tend to see clauses that say that the tenant needs to do the yard work and snow removal. It's really the landlord's responsibility unless the tenant and the landlord have entered into an agreement that specifically says the tenant will perform snow removal or yard work or any type of maintenance. This has to be in writing and there needs to be adequate consideration. What that means is that there's a rent discount or a payment that is clearly specified, which justifies the tenant doing this maintenance work. Now, it's still, if the maintenance we're talking about is repairs, the landlord can't expect the tenant to pay for this. This is, buy the parts or the pieces that need to be repaired. The landlord has to provide that. And again, the tenant needs to get adequate consideration. Next slide, please. Now let's look at fees. Next slide. So deposits and fees are a huge source of dispute between landlords and tenants. And my advice to landlords is to specify any fee that you want on your to assess on tenants. It has to be on your lease, and how this fee will be assessed. The rule of thumb is if it's not written down, you can't really charge it. So think the application fees that's covered by statute 504B period 173. Late rent fees cannot be more than 8%, and that's on 504B period 177. Pet rent and or pet waste fees, where they take DNA samples of pets to track if the waste is being picked up. Fees can be charged, but it needs to be specified on the lease. Smoking fees, meaning cleaning fees if people smoke in the units, or if they allow people to smoke in the units, but then there be a fee assessed for that. That has to be included in the lease. Storage fees, if there are storage units in the building and you want to charge for that, you need to include it in the lease. Any type of early termination fee, be that for advertising costs, or whether you're going to assess a fee, 2 months rent usually, to allow a tenant to get out of a lease early, to buy themselves out of a lease. That has to be specified. And then hold fees or so-called pre-lease deposits, those are covered by statute. You would look at 504B period 175. Next slide, please. Now, fees for utilities in common areas. This is not new, but we're seeing it more post-pandemic. The rule of thumb is if you're trying to pass on the cost of common area utility charges to tenants, you can only do it when when people are in term leases. You can only start assessing that if they resign their lease, if there's a lease renewal. You have to follow the notice period, and you can only include billing that starts the date of that new lease term. For month-to-month leases, you have to give the proper notice to the tenant. And again, the billing cannot include any utility use prior to the start of the new lease term. Also, it has to adhere to single meter rules and its disclosure requirements, which are found on 504B period 215. Next slide, please. Rules and policies. I like to call this the tenant's manual. Next slide, please. They're also a source of dispute, so please include them on the lease. The clearer the lease is, the better it is for everyone. If it's not there, you as a landlord will struggle with enforcing any rules and policies. So think smoking policies, pet restrictions, but you have to comply with the ADA on that one. Illegal activity, if people can have grills on decks or not. Any rule that addresses guests in terms of when a guest really starts to become a tenant because they're living in the property. Any rules that you want in terms of quiet hours. Things like that, you really have to include them on the lease so that everyone can be on the same page. We have a question here on snow removal.
Yeah, we can get to that at the end after you are done with the presentation.
All right, next slide, please. Security deposits, my favorite. So you really need to include on your lease a clear language that says how the security deposit will be paid to the landlord and how and when it will be returned to the tenant. There is a statute that covers this, it's 504B period 178. But a quick summary of it is think about the amount of the security deposit and see if the city has any limits on that. The security deposit must accrue interest at 1% per year. Any deductions that you do for damage has to be damage that is beyond normal wear and tear. And both tenants and landlords really should take videos and pictures before move-in and after move-in so that everyone is on the same page. It provides good evidence of what has happened in the unit. And then the security deposit by law has to be returned within 21 days of move out. So tenants have to give the landlord a forwarding address, and the landlord needs to send the full security deposit if no deductions have been made. And if deductions have been made, then they need to send the leftover amount and the list of deductions. I always advise to include pictures and receipts to prove the reason for the deductions. It just makes the process smoother and it's clearer for everyone. Next slide, please. People have asked us before, is there a lease that we can look at? Because people like to look, will get leases online. So next slide, please. I don't recommend those online leases just nilly-willy because they tend to be from out of state, and some of the provisions in those leases don't apply to Minnesota. A common theme that I've seen from out of state leases is bed bug addendums. In Minnesota, the landlord has to follow 504B period 161. That's the rule on maintenance. So they cannot bill tenants unless they can prove that the infestation was caused by the tenant's willful, malicious, or irresponsible conduct. And the same with pest control. Landlords can't really charge tenants for pest control unless they can show that the tenant caused the problem. Because of this, the lease that I recommend is, next slide, please, is the Minnesota Standard Residential Lease. There's a link here for it. We have it on our website, and it's probably the best lease you can use as a landlord at this moment. That is the end of my slideshow. I think we can move on to the Q&A.
Yes. So thank you very much for all of that, Amma. I know it's a lot going on, and we've got a lot of questions that are coming in, and appreciate that. We also had a lot of pre-submitted questions, so I'm going to go ahead and start that. So Mike, I'm going to put you in the hot seat first, just so that Amma can have some oxygen and some water. All right. So let's go ahead and get started with the pre-submitted questions. Walter, who's an attorney, is asking about a requirement for renters to have renter's insurance at a minimum amount of coverage, I'm assuming in a lease. The example that Walter gives is $1 million in renter's insurance.
Right. So the right way to try to answer a question about can a landlord put something in a lease generally is to think, is there a law that stops it? Leases are always written by landlords. That's just how it works in residential world. Occasionally a tenant can negotiate tiny pieces of the lease, but generally not really. So landlords get to put anything in a lease that they like, as long as it's not unenforceable under the statute. And Amma talked about several areas where that was the case. Here, with renter's insurance, there's no statute that says that a landlord can't have a clause in a lease that says renter's insurance is required, or that there's some sort of minimum amount of coverage that the landlord is requiring as part of the contract. So under the law as we have it currently, Walter, yes, a landlord could have that in a lease.
All right, perfect. Next question is from Lori, who is a service provider. You covered some of this. Lori's just asking for the top 10 things to look for in a lease to ensure it meets Minnesota laws. So you kind of did 5, but also kind of 10. So
yeah. So Lori, I think the best way to look at it is to look at the statute 504B. That really gives the sort of the key things both landlords and tenants needs to follow. And in terms of the main provisions of a lease is to have the name, the address, name and address of both landlords and tenants, how much the rent is going to be. Like I said, include all fees, any and all fees, any rules and provisions, mandatory disclosures, and that's pretty much it, actually. I think it's just, if you look at 504B, you're really going to get a good idea of what the lease should include or not include.
Perfect. All right, let's go back to Mike.
Before we get to the next question, Rachel, if I could just kind of summarize sort of what Amma's been stating a few different times in a clearer way. We see leases on a routine basis that are 50 pages long now. It just doesn't stand out to us at all. I've been doing this since 1996. When I started, leases were 2 pages. Almost every lease was 2 pages. An outlier would be 5 or 7 pages. Now they are 50, sometimes 70 pages. But when you're trying to figure out what do you need in a lease, it really is, I think that there are 4 pillars to a contract, a lease contract. The parties, so who's the landlord, who's the tenant, the amount of rent, the address, and the term. How long is the lease for? Is it month to month or is it a year? Everything else on those 50 or 70 pages, pretty much are rules that landlords like, that favor the landlords, because that's how they write their contracts. And so, but those four things have to be in the contract, or else you don't really have a lease. Anyhow, I'm sorry, I cut you
Yeah.
off before you asked the question.
Well, that was yeah, that's essentially what Amma has as her number one in her top 5 is the who, what, where, and when. But back to our pre-submitted questions. Christine Ann, who's a tenant, I believe, is asking, what can be done when the management doesn't give you a copy of the recertification lease? They say they don't do that.
Okay. So in general, a landlord has an obligation to give a tenant a copy of a lease in Minnesota. There's a state law that requires it. I'm not a giant fan of just throwing around statutes, but if you wanted to do this as a tenant, you could say, hey, landlord, under this statute, and Rachel's going to post it. It's Minnesota statute 504B.115. I need to get a copy of my lease, and I'm arguing that the recertification papers are part of that contract. And I think there's a decent argument for that as well. So if a landlord wants to enforce any part of that contract, they have to make sure that the tenant gets a copy of that, or else they can't enforce it.
All right. And I just popped a link to that specific one, but also the whole chapter 504B if you really want some very light and stimulating bedtime reading. All right. Amma, I really hope that Bridget, might be Brigitte, but Bridget is a service provider and is wondering, in an event that happens like a water leak or something, who is responsible for providing an alternate place to live?
So this depends. If the unit is deemed uninhabitable, the landlord has to refund prorated rent and the security deposit. Mike, is it 7 days or is it 5? It's a
I'm
statute
sorry,
that covers it.
I was reading the next question. What was the question again?
So when the unit has been deemed uninhabitable, for
Mhm.
example, because it flooded,
Yep.
returning the security deposit and prorated rent, is it 7 or 5 days? 5 days. All right, there we go. So the landlord has 5 days to refund that money. If the unit is not deemed uninhabitable, the landlord really needs to relocate the tenant so that the repair can be done. Generally speaking, tenants, I encourage them to have renter's insurance because renter's insurance will cover that relocation expense. But if the landlord can't show that the tenant caused the damage, really the landlord needs to provide a place to move to until they do the repair. Mike, do you have another opinion on the matter?
No. I'm sorry. Again, I was drifting to the next question because we're taking them one after another. Yeah, I think that's fine.
I think that falls into the fit for its intended purpose, and the intended
Yes.
purpose is for living. So that's what a landlord promises to provide. All right, so now we're going on to the next question, Mike, that you have been examining. Fahio is a tenant, and they're wondering if in Minnesota a landlord can incorporate in their lease carpet cleaning or replacement fee to be deducted from the deposit.
So like I mentioned a couple minutes ago, leases are always written by landlords for landlords. That's just how it is. The law tries to step in and balance out the playing field in situations where it can. The security deposit statute is one where the law says it doesn't really matter what your lease says, this is the law. When it comes to repairs, things like carpet damage, carpet cleaning, a landlord can only charge for damage beyond ordinary wear and tear. That's it. That's the limit. So a landlord saying, you know what, I'm going to have an automatic carpet cleaning fee, not really allowed. Last week, I believe it was, a large management company called Housing Hub in the Twin Cities reached a settlement agreement with the Minnesota Attorney General's office where they were forced to pay a pretty hefty fine for having carpet cleaning fees in their leases. And it was sort of an automatic deduction kind of setup, and it's just not allowed. An automatic deduction from a deposit. If you think about what a deposit is, a deposit implies that if somebody performs something, then they get the money back. And if there's an automatic deduction from the deposit, well, it's not really a deposit. It's just a fee. And so it runs afoul of the concept of a deposit, but more importantly, the state law on security deposits, which says, hey, you got to show damage beyond ordinary wear and tear.
Okay.
And Rachel just posted that, I believe.
Yes, I just posted
settlement
the
agreement.
link from the AEG's office for that agreement. And then so Amma just saw this pop up in the Q&A, and just so because we were just on it, if the whole place isn't uninhabitable, it's just like one room that's uninhabitable, like say the bedroom or something, is there a rent deduction or anything like that?
Yeah, what I tell tenants to do is to look at the square footage of the unit, see how much they pay per square feet, and ask the landlord to issue a rent credit for that. If the landlord doesn't do it, you could potentially sue. But generally speaking, landlords will be like, fine, you have a 1-bedroom, you're sleeping in the living room now until this repair is done. I'll give you a rent concession. And I think the key thing here is, while these situations are extremely upsetting, communicating with the landlord is the first and best step to take. Ask, and usually you shall receive.
Awesome, thank you. All right, and I want this next one to be for both of you, because this caused a little bit of confusion when I posed it to the office as a whole. Melanie is a service provider and is asking for us to explain vacant electric fees and vacant service fees. They're saying that they are up to $50 per charge and charged several times. I've never heard of these. I got no response from the rest of our office when I asked if anyone else had heard about these. So Amma and Mike, have either of you heard about these and have any insight into them?
Vacant, you said? Electric fees?
Vacant electric fees and vacant service fees.
I've
Yeah, so
never heard of it.
I'm not really sure what that's about either. I did a quick Google search about it, and I found some stuff from Texas, and it seemed to be hinting at somebody that maybe had a utility not set up in time. I'm not sure. I will say that on fees in general, a landlord can't get fees unless they're in the lease. And so if a landlord is trying to make a tenant pay some sort of fee, it's got to be in the contract, or else they probably don't have much legal footing to get it.
So yeah, apologies, Melanie. It's not something we've heard of. So if you have more information, you can drop us a line, or if there's a particular tenant that is experiencing that, they can reach out to us directly and we can chat through.
On that question, I can guarantee you that whoever you'll reach at the hotline will say, I need to see it because we haven't seen it before. And so an email would be probably the best way to submit that question, because you could attach the documents or the correspondence about it as well.
Yep. Perfect. All right. So then I've forgotten now where I was at. Amma. Flip a coin. Tonia is wondering about accommodations and eviction. So not super specific, but
yeah.
can you give some, you had mentioned at one point about ADA and like pet fees and such. So can you elaborate a little bit more on that?
So reasonable accommodations and housing are covered by the ADA. I like to call it a balancing test, because you have to present the accommodation, and the cost of putting up the accommodation is something that they can look at. It doesn't mean that they can say, oh, it's so expensive, we're not going to do it. But basically the accommodation needs to be submitted to the landlord. Usually bars for bathrooms or showers, those things are most definitely done. If you have a service animal, obviously it's a service animal. It has to be allowed on the property, even if it says no pets. The big issue usually is emotional support animals. And so again, that's covered by the ADA. Landlords usually have a form that needs to be filled out by the person's doctor It's not that you get a card that says I have an emotional support animal. It has to be filled out by the doctor. And the pet is the emotional support animal, I mean, is a prescription. So that's sort of where it goes. The doctor provides the justification, and the landlord, to comply with the ADA, has to authorize the emotional support animal. The key in these issues is landlords can't take a pet deposit to have either service animals or emotional support animals in the property. Any damage that's beyond normal wear and tear that is caused by this animal is the responsibility of the tenant, though. And it will be deducted as per the security deposit rules.
Okay.
And Is right, the ADA does regulate all this. There is a fairly new state law on this as well. Rachel, if you could post that.
Yep, if I can remember which number it is.
113 is the
Okay.
answer. And that's shorthand for 504B 113. 504B is mentioned a lot. That is the landlord tenant chapter in Minnesota where almost all landlord tenant laws reside.
Perfect. All right. Catherine is wondering, Mike, since you've unmuted yourself, how is the market rate listed in a lease determined by the landlord?
A lot of different ways, I'm sure. I'm guessing as if you're a landlord and you just get into the game, one of the hardest things to figure out is what do I charge for rent? And I assume that most landlords try to figure out comparables, right? They look around and they see other units in the area. How many bedrooms do they have? What's the parking situation like? Does it have laundry or not? What's the view? Things like that. And then they see what those types of apartments are going for. And then they try to figure out a rate based on that. Other than St. Paul, there's no rent stabilization, no rent cap currently in place in Minnesota. So a landlord can name whatever price they want. I mean, they could be absurd, right? They could have $1 million studio apartment in Minneapolis. And I can't imagine there's any studio apartment worth $1 million a month in Minneapolis, but a landlord could name that price. Eventually they'd realize, hey, nobody's renting this, so they're going to lower it down to 500,000 and then down to 100,000, and then it's going to end up at some point at its natural place, if they actually want to rent it, at some sort of market determined number. But a landlord is allowed to name whatever price they like. I think that most landlords look for as many comparables as they can find, which aren't that easy to find. When you're trying to find how much a house is sold for, that information is very publicly available. But when you're trying to find out how much a 2-bedroom is in a large building that you drive by, that might not be as easy to find publicly. In fact, it might be impossible to find publicly. It might just be the 2 parties in the world. Maybe you can find the original ad that ran with that number in it, but it's hard to know. So anyhow, landlords try to get as much comparable information and compare it as much as they can and figure out what they think the highest price they can probably get is in most cases.
Thank you. All right, moving right along, we are about halfway through a pre-submitted question. So folks, this is one of the perks about having a pre-submitted question, is that we have a little bit of time to think about them. So Jessica Ama is asking, Jessica's a service provider, and they're asking if you can go over how a victim of domestic violence could go about breaking their lease, and if their security deposit is covered damaged, or if they're billed separately for that.
So let me pull up the statute. Minnesota has a statute. It kind of mimics the VAWA, Violence Against Women's Act. And it specifies what a survivor of violence needs to do in order to break their lease. Let me pull it up.
I put the statute in the chat as well, but it's pretty well listed out there as to what steps need to be done.
So it has the letter in it. There's a letter that basically verified personnel can submit, a qualified third party is what they call it. The security deposit is basically you lose it It's a way of compensating the landlord for the termination of the lease. So in terms of the damage to the property, because the tenant didn't cause the damage to their willful, malicious, or irresponsible conduct, they are a victim of violence. The landlord really can't come after them for that damage.
If the damage is because of whatever violent act happened.
Due to the violent act. If there's damage that happened to the property for other reason, arguably the landlord could try and get that money. I say arguably because the money, the security deposit becomes really liquidated damages to the landlord for having to let this person out of the lease, break the lease. Mike, do you have more insight on this one?
Yeah, no, I think that has to be the right reading of the statute, is that the tenant forfeits the deposit in exchange for getting to use the ability to break their lease early. And so I don't think it does cover damages that are caused. We don't see landlords chase tenants for that all that often, but they do sometimes, yeah.
Thank you. All right, let's move. So Frida is wondering, they're a tenant and they're wondering, don't landlords pay or knock money off the tenant's rent for outside maintenance?
Right. Nama talked about this a little bit in the main speech. Shoveling, lawn mowing are the two main things that we see. So if a landlord wants to have a tenant do that kind of work, whether it's a duplex or maybe a single family home, which is where we see this most commonly, the landlord is supposed to say in writing how much the tenant is getting paid for doing the work. So maybe that means the landlord's writing a check every month for $50, or maybe it says that the lease rent would be $1,000, or if you shovel and mow, it's going to be $950. And it has to be adequate. It can't be just a penny or some sort of token kind of consideration. That's the legal word when you're paying something for some work being done. So yeah, it's supposed to be in writing. It's supposed to be a fair number, and it's supposed to be obvious so everybody can see it as well.
And I'm going to piggyback one of the Q&A questions I think I saw go by. They were wondering if these rules apply to like snow removal and outside maintenance. Does that apply to commercials as well as it does to residentials? And 504B is arguably any landlord tenant, but commercial rules are different than residential rules in a lot of cases.
Yeah, we're not going to cover commercial tenancies here. Sorry.
Nope. All right. Next is Suzanne, who's an attorney. And I can just answer this one. Suzanne, yes, we are applying for CLE credits, 1.5 standard credits. We will email out the code once we get it. It's been taking several weeks, frankly, to get those codes. So apologize that there's a delay, but it is what it is. JAMA is a service provider. Apologize if I mispronounced that. They're wondering if a tenant can be subject to pay utility to a landlord without a meter.
That would be a shared meter or a single meter situation. Statute covers that. And basically the landlord has to have a plan of how that is allocated amongst the different units in the building. It's not nilly-willy. The tenant really has a right to get a copy of the bill, to know how the utility is being subdivided, etc. Rachel, if you can post the statute, that'd be awesome.
While I'm doing that, Mike, can you answer Monfil's question? They are a tenant, I believe, and they're wondering if a tenant passes away or is moved to an assisted living or long-term care, how does that impact a lease?
Right. So if a tenant passes away in a rental property, their estate is allowed to give a 2-month notice. Even if it's a 5-year lease, they could give a 2-month notice to end the lease early. If there are 2 tenants living in the property and they're both adults and one of them passes away, the other one would not have the power to unilaterally end the lease early. They can ask, but they might not have the ability to force the landlord, or they wouldn't have the ability to do that under the law. There is no current law in Minnesota that specifically answers the question about, hey, I need to move into long-term care. It is a law that is being proposed very seriously at the state legislature this year and may become a law. There's a law like that in about 8 states. Minnesota is not one of them, but at present, if a tenant needs to move out for a medical reason, short of death, there's no specific law that says that the tenant has the right to vacate immediately. Now, a tenant could make a reasonable accommodation argument, but it's not a guarantee that a landlord would agree with that or that a court would necessarily agree with that either.
All right. Gale is a service provider, and they are wondering if there are additional rule packets attached to a lease that the landlord wants you to sign. Are those allowed? For example, the example they include is tenants can't wear shirts with writing, so like a dress code. How enforceable are those?
So there's something called free speech. And so a landlord can't regulate that. But generally speaking, there can be a manual of policies for the property that still can't interfere with federal law or state law, to be honest. I think what would be interesting is if you could contact us by email and send us a copy of this packet so we can look at what exactly is being asked of tenants.
Yeah, the free speech question isn't that easy because free speech can't be regulated by the federal government is what the First Amendment is about. So in a contract, can one party regulate it with another one? I can tell you that I've done some research, usually in election seasons. We get contacted by tenants who say that a landlord says, oh, I don't like that candidate. You put a sign up for that candidate, so take that sign out of your lawn, and had to do some research into that. The basic rule that we came up with was that a landlord likely could bar all signs, but couldn't bar specific, like no political signs, and certainly couldn't say no Republican signs or no Democrat signs, that would be a problem. And the ACLU has worked on cases like that. So there might, I mean, I've never seen a no writing on a t-shirt lease clause. That doesn't mean it doesn't exist, because we see new lease clauses about once a week. Despite the fact that we look at a lot of leases, landlords put creative things in there. And I guess there might be some landlord out there that just truly despises writing on clothing, which must make for a harrowing experience in life. There's just a lot of clothing that has writing on it in society. So I don't know how they avoid that. But anyhow, I've never heard that one before. We'd want to see it for sure.
Mm-hmm. All right, we have honestly just a couple of questions, pre-submitted questions left. Most of them actually have either been covered. So I'll just go through them real quick, and we have about half an hour left to get into all of the questions that were submitted during the webinar. So we will see where we get on those in the next half hour. But Ed, a service provider, wants to know if there's a recording of this. Yes, we will record. This is being recorded and it is being put on our website. Look for that in the next few days, maybe next week. The guy who does our website updates with these is out of the office right now. So Boaz is a tenant, and they're wondering about repair issues, and those are things that I think this is a very specific question that you should contact us directly, either by email or over the phone, to discuss what options might be available for getting repairs done. Roxy wants to know about tenants getting a copy of their lease. We talked about 504B.115, that it's a requirement that tenants be given a copy of their lease.
Sorry to interrupt you. There's a letter on our website, homelinemmn.org. You can send to the landlord to request a copy of the lease. Just print it out, fill it out, take a screenshot, send it to the landlord by email, send it to them by certified mail, drop it off in the office. Make sure you always keep a copy of these things. But yeah, the landlord has to give you a copy of the lease.
And I just posted a link to our form letters in the chat. And then Ida is a service provider, and they want to know if a person is behind on rent for, say, 4 months, but then pay the rents on the 5th month. So landlord hasn't filed, I don't even know if the landlord's filed an eviction or not, but basically tenant is behind, but then they pay, say they're behind January through April, but then they pay in May. Where does that where do those funds get applied to? Is it the first month of non-payment? Like, is it backfilled, or is it just to that May month?
Um, really, it's just a debt for late rent. So what month it gets applied to is a little bit irrelevant. You can write on the check or on the money order for May rent. That's not really going to delay the landlord's right or possibility of filing for eviction. What it's going to change is that one of the months, one of the late fees won't include the 8% for that late rent for that 5th month that you're paying rent. So late fees are applied at 8% per month, or maximum of 8% per month based on the debt that exists for rent. So that deduction is going to be made from that possible late fee application. Was that clear?
Yeah, so basically it's an accounting process of where the landlord applies that to, but if you stipulate in the payment that it is for a specific month, if it's the current month, ideally you should be able to avoid a late fee on that month. All right, and then Shahidul is a tenant and they were asking about security deposits and moving out charges. We've kind of covered that quite a bit. So if you have any more specific questions and you are here and listening, feel free to drop that in the Q&A and we'll try and get to that. All right, you two, let's move on.
Okay.
Ready? So I'm in the Q&A. I'm going to go through these as best I can. So Anonymous wanted to know about breaking a lease for death or illness. Mike just covered this, so we'll go
Yes.
ahead and move to the next one. Tsunami is saying that the landlord is charging an extra fee that is not on the lease. For example, a vacant fee or account setup fee.
So we covered that earlier. If it's not on the lease, really the landlord can't charge it. If you can send us an email through our email and attorney feature on our website with the document of what you're discussing, that'd be extremely helpful so we can give you a very specific answer tailored to the situation that you're in.
Gail similarly is asking, any fees? I just reviewed a ledger that had a fine $25 for using the laundry after hours. If in this lease, then is that acceptable?
So it gets a little bit complicated, fees, Ken. So what if a landlord put into the lease that if you use the laundry after 11 at night, there's a $10,000 fine? Would a court enforce that? Well, the first thing the judge would look at would be, okay, is it in the contract? If it's not in the contract, there's no way the tenant can do it. But if it is in the contract, it still has to be a reasonable forecast of what the landlord's costs are. It can't be a penalty clause, can't be punitive. It has to be compensatory somehow. So I'm not exactly sure what the $25 is for or what it's covering. But starting point is it has to be in the lease. The landlord can't just make up a fine and throw it in the middle of the contract. But the next question is it a fair number is kind of the way to think about it. And what is it paying for exactly? So maybe the most common type of fee like that we see is usually in college areas where a landlord will have something like a $500 fee if a keg, full or empty, is discovered in an apartment. And the right way to ask a question about that is, okay, what is the landlord having to pay $500 for? Is there a city fine of $500 if a keg is discovered in private residence? I doubt that. But if there is, I guess the landlord's just passing on that cost. But where's the $25 number come from is a much deeper analysis. But start with the lease. If it's not in the lease, landlord can't do it.
Fabulous. Ida has a couple of questions about bed bugs. So if a property that you are renting gets bed bugs from someone in the building, can the person break the lease? And does the landlord have to do a hot treatment versus a chemical treatment?
So breaking the lease is tricky because the unit needs to be deemed uninhabitable. Normally what happens is you would submit a repair request. The landlord gets to pick the type of treatment they use, chemical versus hot treatment. I know hot treatment is preferable. It burns them, disintegrates them, kills them. Chemical treatment takes longer. So unfortunately, you don't get to pick as a tenant. Basically, you submit your repair request. The landlord will address the issue. If they don't, then you can file for rent escrow in court. And then it's a hearing, it's a court process, and the referee or the judge will set a timeline for the landlord of when they have to do what they have to do the treatment. You can also call a city inspector. Usually if bed bugs are jumping from unit to unit to unit, it means that the problem is just a bigger one. And cities can request that landlords do more. So keep that in mind.
Mike, Emily just has a very pointed question. It says 504B.145. For the rest of us, that is the statute that says restrictions on automatic renewals of leases. Your favorite topic.
Is it?
It is.
Is it? Just like how mine apparently is the rules against perpetuities, according to Amma.
Yeah. So the automatic renewal statute is a complicated statute and somewhat ignored statute by a lot of landlords. So here's how it works. If you have an original lease of 2 months or more, let's say it's a 1-year lease that has a notice provision at the end that says if you don't give notice, then the lease will renew automatically. Let's go to the extremes, which is how it used to be when this law was passed in the 1970s, where leases would renew automatically for another year unless the tenant did something to end the contract. So you sign a 1-year lease on January 1st, and unless you warn your landlord, hey, I'm going to move out at the end of this lease somewhere during the lease, depending on how much notice the lease requires, then it would renew for another year if the tenant does nothing. That's not really what most landlords do these days. Most landlords have a renewal that happens for 2 more months automatically if the tenant gives no notice at the end of that 12-month period. So this statute says if the original lease is 2 months or more, so 1 year, and the renewal is 2 months or more, which most are, then the landlord can only require a notice if they pre-warn the tenant during the contract. The theory is tenants don't sit at home every night reading their leases, wondering, what do I need to do to comply tonight with my contract? I signed a 1-year lease. I assumed it was a 1-year lease. Why is it a 14-month lease? So the landlord has to warn the tenant. Using our calendar example, the landlord would have to warn the tenant between October 2nd and 16th in writing that their lease is going to renew automatically for 2 more months unless the tenant tells the landlord by Halloween at the latest that their lease is renewing automatically. And the landlord can only tell the tenant in one of 2 ways. First of all, it has to be in writing, but it can be either by certified mail, which is where you signed for it, that stands out in most people's mind, or by personal service, which means one person handing it to another. And so those are rarely done by landlords, the certified mail or the personal service. But yeah, it's a statute on the books and it gives tenants some leverage if in month 11, they're trying to give a notice and the landlord says, no, you needed to give 2 months notice. And the tenant says, well, you didn't warn me. Then the tenant has some leverage under that statute.
And that is specifically for leases that are renewing for an additional period of 2 months or more.
Right.
So like if you were in a month to month, that wouldn't necessarily apply. Right. Yeah.
Mhm.
All right. Amma, Anonymous is wondering, does snow removal include specific spots or just the main road around the parking lot?
So snow removal includes the property anywhere like you're walking. I know some cities have requirements as to where snow needs to be removed, but basically parking lots, walkways, if you can slip and slide, the snow needs to be removed. And I know that does become an issue, especially with houses or duplexes. But basically it falls into the fit for the use intended. If you are going to have people walking there, you have to clear it.
Perfect. All right. Ooh. Okay. Mike, Emily has two questions about guests. So what can you say about guests, and can you really limit guests?
Oh, there's an expression about how long guests are supposed to stay. I can't remember. It's something about fish. But anyhow, it doesn't matter. Can you really limit guests? So I think from the landlord's perspective, can they limit guests? Yeah, and a lot of leases do. A lease will say that a tenant can't have somebody stay with them 7 consecutive nights or more than 14 nights in a year. Is that lawful for a landlord to do? Sure. A landlord can put that in the contract. A tenant does have a right to have guests. It's where you really have trouble is when people move in. Most leases don't really truly stop tenants from having guests. They limit somebody from moving in. That's really the goal of the guest provisions that you see in most leases. And that gets to be kind of difficult to figure out where somebody lives. But we talk to tenants all the time that have somebody that's been staying with them for what they thought was going to be 3 days and it turned into a month. And now they're facing some pressure from their landlord who has no idea who the person that's living there is. Especially during the winter, if there's parking issues, people really notice next door that there's no parking left because there's extra people around. So yeah, a landlord can limit people moving in for sure. And it's usually called a guest limitation policy, but it's mostly about people living there.
Perfect. Thank you. All right, Amma, Jessica's wondering, what about written notices as like a note on the door that now becomes part of the lease? So a
So
policy
that's-
update or something.
Oh, so if you're in a term lease, you would have to agree to it. So because it's an amendment to the lease. If you're month to month, the landlord really has to follow the notice requirements. So usually it's 30 days, but if your previous lease had a 60-day notice, so then that would carry on to your month-to-month tenancy, and it would be a 60-day notice period for any changes to the lease. So that I mean, that's basically how landlords have to address it. You can't just nilly-willy make changes to a lease, staple it or tape it to a door and be like, well, that's a new rule. That's not how it works.
All right. Mike, Anonymous is wondering if the landlord is required to test water to show that it is safe to drink if a tenant asks for the water to be tested. In this case, the apartment is in a building that is on the city water lines and not an individual well.
I don't know of any law that requires the landlord to test the water if the tenant asks for it. Now, a tenant could certainly test the water themselves, and if it comes back and there's some sort of health problem with it, then they would have some footing to go in a lot of different directions. But is the landlord required to simply do this because the tenant says, please? No, I don't know of any law that requires that to happen.
So Anonymous is this is more about snow removal. I suppose it is that time of year. Snow removal is looming large on everyone's mind, but I don't actually see that there is a question in this. But curious about how to essentially, if the landlord doesn't plow properly, how do you force that issue?
So you would submit a repair request, call a city inspector. Obviously, you said the city says that it's private property, so they're not going to intervene. But it would be a repair request, 14-day repair request requesting plowing to be done, snow removal to be done. What I advise tenants to do is that get together, have tenants do it, submit the repair request forms all together. That tends to put more pressure on landlords. Also, keep in mind, with the amount of snowfall we've had, the snow needs to be put somewhere. So what that means is, like, sometimes not every walkway will be available. Doesn't mean that that's okay. It just means that sometimes we have to be mindful of that. Like the snow won't be carted off site. It needs to be so that people can walk and not fall. So we do have a repair request repair request letter on our website. Landlords usually have the tenant where you pay the, what is it they call it, the tenant website, where you submit maintenance requests. You can do it that way, or you can submit a repair request letter. You can write your own too.
Oh, like the portal? Is that what you were looking
The
for?
portal, yeah.
Gotcha. All right, perfect. I will put in the link to our forms again. This is a security deposit question. So basically, tenant moved out and got billed for cleaning a month and a half after the fact. So can you detail a little bit, Mike? So this is a very specific question that I'm just going to say that if you've got that level of specificity, you should call us. But in general, what does a landlord have to provide in the letter if they are going to withhold some of the security deposit?
Yeah, so kind of the intro to security deposits is the tenant moves out, they terminate the tenancy, they give a mailing address to the landlord. That has to happen, some type of mailing address or delivery instructions. And then within 21 days, I think they said a month and a half in the question, within 21 days, the landlord is supposed to send a letter saying what happened to the deposit or give the deposit back to the tenant. If the landlord is going to keep the deposit, the law requires that the landlord state, I believe, just doing this verbatim from the statute, I think it says specific reasons for keeping the deposit, specific reason. It doesn't say you have to give receipts. It doesn't say you have to show
Pictures.
anything more than the word specific reason. Other states has a lot more detail as far as what the landlord is required to give when justifying keeping a security deposit. This is the kind of case that is probably ripe for going to conciliation court, small claims court, which costs a tenant about $70 to file. You can sue for up to $15,000 there. There might be some penalties available. Rachel said, give us a call or send us an email at our email and attorney page, which you see on the main site. In fact, I got an email in the middle of this speech from a tenant directly to me, and I would ask that tenant to submit it this way, which we have some intake questions that we have to ask pretty much everybody and they help inform some of our answers as well. But yeah, we would want to know the details because there might be some penalties available. The first thing I know that I would be asking you though is, did you give the landlord a forwarding address? When did the lease end exactly? Did you give a notice? Did the landlord give a notice? But is it clean as far as the end of the contract goes? And then when did they finally send you something? Because if they missed the 21-day deadline, it gives you quite a bit of leverage depending on how much your deposit was to begin with.
Right. All right, thank you for that. I'm not 100% certain. Tressa is saying that they are piggybacking off of a question by a previous requester, but they're asking about if a tenant had an accident and cannot work for 3 to 6 months.
So I remember I had this question. This is about breaking a lease. I mean, if you've had an accident and you haven't been able to work for 3 to 6 months, unfortunately, the Minnesota law doesn't cover illness or disability to allow a tenant to break a lease without penalty. The rule of thumb here is if you have been out of work and you have a debt pending, you can consider applying for emergency assistance from your county to see if they can cover the rent that is owed. Otherwise, negotiate with your landlord would be the next step to be released from the lease. If ultimately you have to break the lease, no one can hold you to it. Like no one can chain you down to your unit and say you can't move out. You have to move out, you move out. What happens is it will probably be sent to collections, which means your credit will take a hit. But you're not locked in to the unit. It's just there will be penalties that you will have to deal with later.
Yeah.
Unless the landlord re-rents.
Yeah,
if they do, then the
exactly.
tenant's off the hook. The landlord can't get the double rent.
Yeah.
Very true.
All right. We've got about 10 minutes left according to my clock. So
Plenty of time.
Yeah. We've got 15 questions left, it looks like. Some of them are going to be a little bit more involved than others. I don't know if you two have a little bit of time to stick around after 3.
Yep, let's
I
just keep
do.
plowing ahead.
Perfect. Because these are great questions, so thank you all. Definitely the width and breadth of landlord tenant 504B. Um, so this is a question about pet deposits. We on Mike, I think. Do you only, for pet deposits, do you only get part back or zero back because of like an automatic pet sanitation fee or something?
Yeah, the big word that stands out in that question is automatic. That somehow there's a deduction from a deposit that happens automatically, which, as we talked about earlier, a landlord is not allowed to have an automatic deduction from a deposit. So yeah, absolutely give us a call about that, or complain to the Attorney General's office, because they're working on these kinds of cases clearly with even the biggest types of landlords like Housing Hub.
Okay, Amma, can you describe what's required in the lease to comply with 504B.181? So this specifically is a landlord or agent disclosure.
So they need to disclose the name and address of the person who manages the premises, and the agents that are authorized to accept, process, receive receipts, get rent. Let's see, there's a posting requirement. So they need to post their permit in a visible place. I've seen that with the rental licenses. You have to post it on the front door. And then for the service of process part, is basically it's the address of the landlord or the management company that's disclosed on the lease. And it's usually also on that notice that has to be posted on the door. And then information on how to handle maintenance. So emergency numbers that the tenant needs to contact after hours. If there's a portal for tenants, how do you submit maintenance requests, etc.
Yeah, this is generally seen as what we call a threshold defense to evictions, 504B.181. And so if a landlord doesn't comply with this, it can cost the landlord another 30 days. And the main thing the landlord doesn't provide to the tenant is their actual address, a street address, versus a PO box or something like that.
Yep. All right. So the next 2 questions I think are combined, so I'm going to combine them. Anonymous was told by another attorney that emotional support animals are not covered under the ADA, and they're wondering if landlords can say no to an emotional support animal. So I mean, you covered this a little bit, but Mike, what do you got on
Yeah,
this?
so to begin with, again, that we have the new state law that in a lot of ways really mirrors what litigation we've seen at the federal level. We posted it earlier, 113, I think it was, we decided.
Yeah.
Yep. So a landlord saying no to an emotional support animal. Look, I'm a tenant attorney, but if I were a landlord attorney and my client called me up and said, hey, can I say no to an emotional support animal? And I said, absolutely, you can say no to that. I would be sued for malpractice as a landlord attorney. That is just not correct. A landlord can't just say no to an emotional support animal. There's a statute, and if the tenant complies with it, then the tenant gets to have the emotional support animal. As far as the ADA, there's another question, I believe, from Diane later on as well, which is it the Fair Housing Act or not, or the ADA? I think it's the Fair Housing Act is the one that technically covers this. These are really kind of, but first of all, we don't do a lot of discrimination law. We know enough to know the basics about it, but these are federal rules. And I think it's the Fair Housing Act that actually applies to the emotional support animal, not the ADA specifically.
Yeah, and I just dropped a couple of links in, one on the statute again, but also some resources for how to navigate emotional support animals in Minnesota. One is from Housing Link, and the other one is actually the HUD guidelines. Again, a very riveting, light bedtime read if you have insomnia.
Housing Link has a cool form, 2-pager that kind of summarizes it. I usually recommend to tenants to present it to the landlord if they're having any issues. I don't think most landlords say no to things just because they want to say no to things. I think oftentimes it's because they don't know. And so little information goes a long way.
So yeah, I dropped some links in there. Alma, since you were off mute, Shalimar is wondering if there's a max deposit or monthly fee allowed for pets.
No. It can't be punitive, though, and the fee needs to be listed on the lease. I
Minneapolis.
think in
There's a
Minneapolis.
Minneapolis rule. Yeah, on the deposit.
All right.
Other
So
than
there
that,
you
no.
go.
Yeah.
I think I've seen the most I've ever seen for a pet deposit, and this is not to give ideas to landlords, but it's about $75 of pet rent. And I think it's for the first pet. If they allow additional pets, so the rent goes lower. And for the deposits, I don't think I've seen anything over $250, but I could be wrong.
Yeah, maybe I might have seen 500 before, but I mean, there's no cap on it. There's no cap on deposits in general in Minnesota.
Yeah.
So.
Yeah, sorry, here I just dropped that Minneapolis ordinance on security deposits that Mike referenced, but but that's the only one that I'm aware of as well. All right, Mike, since you're here, is normal wear and tear for a non-animal unit? This is about pet deposits, I think. Is it normal wear and tear for a non-animal unit, or is the service animal taken into account when assessing what normal wear and tear is?
Yeah, I think it's just normal wear and tear. I don't, and again, not a discrimination attorney, but I don't believe that you get a free amount of wear and tear because you have a service animal in a property. But I haven't done that kind of litigation that much, so take a federal search on it.
Gotcha. Can a landlord take a non-refundable pet deposit out of the security deposit for an emotional support animal upon move out?
No. I mean, the non-refundable pet deposit, I mean, I guess the question would be, did you fail to pay the non-refundable pet deposit? Security deposits are to cover damage beyond normal wear and tear. However, if there's a debt that's left with the landlord, they can really deduct it from the security deposit because it's still a debt that's pending.
But this is for emotional support animals specifically.
Okay, so I'm sorry, I take that back. So they can't charge a non-refundable pet deposit for an ESA or service animal, period, full stop. So if the landlord has made the deduction from your security deposit, you can sue them in conciliation court for that. They just can't have a pet deposit for them.
Or pet rent.
Or pet rent, true.
Yep. All right, Mike. So say that there are repair issues in the apartment that need to be repaired right away, but the tenant waits a couple months to ask for them to be repaired. Is the landlord still responsible to repair this?
It looks like the next question might be kind of a follow-up to that too.
Okay. Yeah, and so that one's a little bit more serious. So the first question was about like broken closet doors or broken towel bars or something. The second one is listing like water damage that the tenant doesn't report about right away.
Yep. So yeah, to start with, if a tenant has a broken closet door and they don't tell the tenant, or I'm sorry, the landlord right away about it, does that mean that they're barred from doing that later on? I don't think so. If I'm a tenant and I move into a place, I'm going to want to tell the landlord right away about all kinds of repair problems, just because I want to make sure I get my deposit back and I don't want to be blamed for anything, especially like a closet door where they're going to claim frequently that it was tenant caused or else it wouldn't have broken. Water damage is a different kind of animal completely. Water damage never gets better on its own. If there's a leak of some type, it's almost always going to get worse. And so if the tenant sees that underneath the kitchen sink, there's a leak, and they don't bother to tell the landlord about it, could the tenant be in trouble later on for extra water damage? And I think maybe so. I mean, maybe that's the tenant being irresponsibly, responsible under the statute, the repair statute, for not warning the landlord about what's going on there. I mean, tenants really are paying house sitters. And so A landlord generally wants this kind of information. No landlord wants to hear about water damage 3 months after it started. They want to hear about it right away. They might not like the notion that they have to fix something, but they're not going to like it more because it's 3 months worse damage. So if I'm a tenant and there's a leak, I'm telling the landlord about it, probably with a phone call right away, with a text and an email, and maybe even a letter soon to follow, so I can show if I need to later on. I told the landlord. They're the ones who chose to do nothing about this.
Yeah, and it looks like there was one more follow-up, the third follow-up after that.
Hmm.
So say as months after you moved in and you're noticing more minor damages in the apartment, would you just continue to take pictures? And can the landlord at any point try to blame you for them, even if it wasn't you?
Yeah, I mean, I was in a high school last week talking to a bunch of students about getting their first apartment and not messing it up. And one of the things I tell them every time is walk around with a camera the day you move into your place, look for anything that's wrong and look everywhere, because I guarantee you when you move out, the landlord's going to look everywhere for damages. If you want to get your deposit back, that's the single most useful piece of advice I can give is photos on day one. So walk around. But yeah, I mean, if you discover something after a while being in the place, but you didn't cause it, sure, you can still point it out to the landlord and say, I don't know how long this has been here, but we didn't do it. And I just noticed it now. Here's a quick photo of it. Sure, no harm in that.
All right. Emily had a question about what if you start with a month-to-month lease? I don't have any context for that one, so I don't know if Emily can give a little bit more context and we can come back to this question.
I'm going to assume that what she means is what if I start with a month-to-month lease and then go into a term lease? You can definitely do that if that's what the landlord offers. You start in a month-to-month lease. Usually, month-to-month leases, especially with corporate landlords, there's an additional fee. You decide you like the unit, you can just go ask the landlord to sign a lease. And if they offer it, you can go ahead and sign it. But if you need, if you have more context for it, we'll appreciate it.
Right. Amma, since you're here, I'm going to have you answer this one too. I've had clients whose landlord had placed their renewal lease under the door. Can they do that?
I mean, yeah, it's just, did they follow the notice requirements? Did the tenant see it? Basically,
I think
you
they're
should.
asking about automatic renewal compliance here.
Oh, okay. If it's
Yeah.
automatic renewal compliance, go ahead, Mike.
Yeah, that does not meet the definition. Yeah, certified. If you think about what it's rare in landlord tenant law. I don't know of any other situations where certified mail is required. Certified mail is one way to give a renewal notice if you're doing the automatic renewal compliance. Again, when you get regular mail, the 60 cents or whatever, you never see the postal person most of the time, right? They might see you, but they put it in your box or they put it wherever they put your mail. When the whoever's delivering the mail says, hold on, I need you to sign for this one, it really stands out. That's one way of two ways a landlord can give a renewal. The other way is to hand it to you. They don't have to say anything, but they actually have to physically hand it to you. So sliding it under the door, taping it to the door, regular mail, it's not enough. It's one person handing it to another or certified mail. Those are the only options you have. Because it's important. You're going to renew it. You're making a 12-month contract into a 14-month contract. It's quite a transformation. And so something should have to happen to make that allowable.
All right. So Danielle is saying, I heard recently that the landlord only has an obligation to deal with black mold if it is in a condition of the lease or from water damage where the source is identifiable but isn't from tenant cause. Is this true?
No, maintenance is still the providence of the landlord. Look at 504B 161. They have to, if you see mold, you submit a repair request. The landlord has to go look at it and make a determination of whether it needs to be repaired, etc. You can also call the city if your city has a city inspector, even though they don't really like to look at mold issues, and make a determination. The city inspector can make a determination. Some tenants also get mold testing kits. That's basically to support your case. If the landlord's like, I don't want to deal with that, and we're like, well, it tested positive for mold, so I need you to come deal with it. It would be a 14-day repair request, and then you could file for rent escrow.
All right, 2 more questions. We got this. So it sounds like there's a lot of issues with whether, so the ADA says you can't charge for pet fee for service animal. If you can, they're wondering if you can charge one for an emotional support animal. So statute 504B.113 does say that an emotional support animal is a support animal, or a service
Yeah.
animal.
So, I mean, if I'm a landlord and I'm trying to figure out what do I need to do to comply on the ESA front, I think I'd start with the state law because it's a little clearer and it
Mhm.
certainly applies to Minnesota. There's no question about that. There have been no court challenges that I know of that said it doesn't apply or it shouldn't apply. It's not the only question, though. There's still also the federal question as well, the fair housing question. And so, but I would start with complying with the state law as a landlord. And yes, the state law says an ESA is effectively not really that meaningfully different than a service animal. Yeah.
Yep. And one thing I think was different part of this question is, can a landlord charge fees or evict for a nuisance and emotional support animal?
In short, yes. You'd have to convince a judge that it's bad enough. If it's an ESA, there's going to be a balancing test between reasonably accommodating it. I mean, the example I always give, which is, I'm tired of the example, but it makes sense. So if you're in a 1-bedroom apartment and you want to get an ESA that's an elephant, it's going to cause a bunch of damage. That's not a reasonable request. Whereas if you are renting a property out in greater Minnesota where you have a lot of land, maybe an elephant could be a reasonable accommodation request. At least it's not an unreasonable one based on the space limitations that you have. So a landlord could technically evict for certainly an animal when it's not an ESA or service animal if they're causing problems. And maybe they can if it's a service animal or an emotional support animal as well. It's just that they probably have to get to a higher bar of how much of a nuisance the animal actually is.
Perfect. All right, Anonymous is wondering about lease terminations on a month-to-month lease. They only do month-to-month leases, and just wondering about the notice time and what if a tenant refuses to leave by the end of the lease.
So for month-to-month leases, look at 504B.135. You can terminate a month-to-month lease by giving written notice. 30 days is usually the rule unless your month-to-month lease says that it has to be a longer period. If the tenant refuses to leave by the end of the lease, then the next step would be filing an eviction for holdover.
And yeah, the rental period, there's also some case law that says that you have to put the vacate date for the end of that rental period.
Correct.
So most rental periods are going to be the beginning of the month to the end of the month. It depends on when your rent is due.
Yeah,
So-
you can't just do it at the end of the mid-month if that's not when the rental period is happening. It's 30 days at the end of the rental period. So you normally would receive the notice or give the notice with the last rent that you receive. So on the 30th or the 31st.
Yeah, so like say, but if you got notice that you had to vacate, say April 1st, you couldn't have it be effective for April 30th because that's not a total
Correct.
rental period. It has to be, if you gave notice on April 1st, then it would have to be for May 30th, basically. 30 days have September, April, June, May 31st.
May 31st.
All right. And then finally, we got one more question. Can a landlord have you sign a form stating that the tenant is responsible to clean any black mold as it appears on the walls or windows?
Sure, the landlord can have you sign a form that says that. The question is whether it's going to be unenforceable or enforceable. What happens with when a court looks at that? So we go back to 161, which is our statute on repairs, and the landlord can only make a tenant do that if they pay them to do it, basically. And it's got to be fair payment. Also, the landlord can't pass on the responsibilities of doing this, and they can't hold the tenant liable for the black mold unless they can show that the tenant caused it irresponsibly. Mold is, it's not a, hey, we get one call about this every 6 months or something. This is a constant problem that tenants and landlords are dealing with, and it can be very contentious. So if you're a tenant out there dealing with a mold problem, please give us a call. We'll try to figure out your best options going forward.
Well, that is it for the questions, and actually segues very nicely into our next webinar is going to be in April on the 19th, and that is going to actually be a couple of city inspectors, one from Minneapolis and one from St. Paul, are going to be coming in and talking to us about what they do, what they don't do, and what their process looks like. So keep an eye out for that registration coming soon. But I want to extend a really, really, really big thank you to Amma and to Mike, both for sticking around, answering all these questions. I think it's been really helpful and really great. This recording will be up on our website shortly, and we will get out that CLE credit number very as soon as we get it. So, which could be a couple weeks, like I said. So, and thank you all for coming and joining us today. It's been a really great day. And again, feel free to reach out to us, and thank you. Have a wonderful day, all.
Thank you. Bye.